USCIS Updates fees. Judge extends temporary protected status. I. 693 medical exams. ICE moves to end bond hearings for detained migrants. U.S. will review social media. H. 2B visa cap increased and U.S. Immigration Service to change. If you are interested in this, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. USCIS Updates fees based on H.R. 1. The U.S. Citizenship and Immigration Services has issued a Federal Register notice implementing significant changes to immigration-related fees as required under the H.R. 1 reconciliation bill. These new fees will take effect for all applications and benefit requests postmarked on or after July 22, 2025. Any form submitted on or after August 21st, 2025, without including the proper fees as outlined in the FRN, will be automatically rejected. These fee adjustments apply to a wide range of immigration services and are designed to help USCIS fund operations through the Immigration Examinations Fee Account, with some revenue going to U.S. Treasury's General Fund. Importantly, the FRN states that these fees must be adjusted annually based on inflation. Among the newly established fees, applicants filing Form I-589, application for asylum, and for withholding of removal must now pay a $100 application fee. Additionally, a new annual asylum fee of $100 will be charged for every year the application remains pending. This annual fee must be paid online, and USCIS will send personal notices to applicants each year specifying the due date, amount, and payment instructions. For those filing Form I-765, application for employment authorization, under specific categories, such as asylum seekers, parolees, and those with temporary protected status, the fee will be $550 for initial EAD applications and $275 for renewals or extensions. However, applicants requesting a new EAD after receiving re-parole under Form I-131 will only need to pay the lower fee of $275. A new $250 fee has also been introduced for special immigrant juveniles filing Form I-360, and the TPS registration fee using Form I-821 will now rise significantly from $50 to $500. For asylum seekers who filed their Form I-589 on or after October 1st, 2024, the AAF will become mandatory after 365 days of the application remaining pending in each year thereafter. USCIS will monitor these dates and inform applicants accordingly. The new fees established by H.R. 1 do not replace the existing USCIS fee structure listed in 8 CFR Part 106, but rather charge in addition to them. This means that applicants may need to pay both the original USCIS fee and the H.R. 1 fee for the same service. While certain existing fees remain eligible for a fee waiver via Form I-912, H.R. 1 fees are non-waivable and non-reducible, placing additional financial responsibility on applicants. Moreover, changes have also been introduced to employment authorization validity periods, limiting EADs for parolees and TPS holders to a maximum of 1 year, or the length of their authorized stay, whichever is shorter. Judge extends temporary protected status for 60,000 people from Honduras, Nicaragua, and Nepal. A federal judge in California has extended temporary protected status for approximately 60,000 immigrants from Nepal, Honduras, and Nicaragua, just weeks before their protections were set to expire. TPS allows foreign nationals from countries experiencing natural disasters or political instability to live and work legally in the U.S. without fear of deportation. The extension comes in response to challenges against Homeland Security Secretary Kristi Noem's decisions to terminate TPS for these countries. Noem claimed that conditions had improved in their home nations, referencing recovery progress in Honduras and Nicaragua since 1998's Hurricane Mitch. TPS for 7,000 Nepalis was due to end on August 5th, while 51,000 Hondurans and nearly 3,000 Nicaraguans were set to lose protections by September 8th. This termination is part of a broader push by the Trump administration to dismantle humanitarian protections and enforce mass deportations. Critics, including lawyers from the National TPS Alliance, argue that these decisions were politically motivated and not grounded in objective assessments. They contend that TPS recipients were given only 2 months to leave, far less than the usual 1-year period. Furthermore, TPS has already been revoked for hundreds of thousands of individuals from Venezuela, Haiti, Ukraine, Afghanistan, Nepal, and Cameroon, with many still entangled in ongoing lawsuits. The Justice Department defends NOAM's authority, claiming her decisions reflect the administration's legitimate immigration and foreign policy goals, emphasizing that TPS is designed to be a temporary solution, not a path to permanent residence. This ruling marks a significant development in the fight over TPS, highlighting ongoing legal battles, questions of executive authority, and the human impact of immigration policy changes in the U.S. I-693 medical exams. USCIS Update. I-693 medical exams now expire with your case. Today, we're diving into an important USCIS update about Form I-693, the medical exam for immigration. Did you know it now expires with your case? Let's break it down in 2 minutes. Form I-693, the report of immigration medical examination and vaccination record, is required for green card applications. Since June 11, 2025, USCIS updated its policy. If your Form I-693 was signed by a civil surgeon on or after November 1st, 2023, it's only valid while your application, like Form I-485, is pending. If your case is denied or withdrawn, you'll need a new I-693 for future applications. This change ensures public health safety but may mean extra costs for re-exams. For exams signed before November 1st, 2023, the 2-year validity still applies. Always submit Form I-693 with your I-485 to avoid delays. SIJS youth no longer protected. Work permits at risk. Today, we're diving into a critical update affecting special immigrant juvenile status youth. As of June 2025, USCIS has ended automatic deferred action and work permits for these young immigrants. Let's explore what this means and why it matters. SIJS is a humanitarian protection for youth under 21 who face abuse, neglect, or abandonment. Since 2022, deferred action allowed them to live and work legally while awaiting green cards, often delayed by visa backlogs. The recent policy change strips new SIJS recipients of this protection, leaving them vulnerable to deportation and labor exploitation. Existing permits remain valid until expiration, but can't be renewed. Advocates, like the End SIJS Backlog Coalition, are fighting back, filing lawsuits to reinstate protections. This shift impacts over 100,000 youth, many fearing an uncertain future. ICE moves to end bond hearings for detained migrants, memo shows. ICE ends bond hearings. U.S. Immigration and Customs Enforcement will no longer allow detained migrants to request bond hearings before immigration judges. Instead, release is only possible through a rare Homeland Security exception. Legal authority and policy shift. Citing a 1996 law, ICE Acting Director Todd Lyons stated that this decision gives ICE broader detention powers. The policy took effect immediately and is expected to significantly increase detentions. Political and legislative background. The move follows the Laken-Riley Act, signed by Trump in January, mandating detention for undocumented individuals charged with even minor crimes. ICE is being bolstered with $170 billion, including $45 billion for detention. Detention surge in capacity. As of June, ICE held 56,000 detainees, above its budgeted capacity of 41,000. New funding aims to support a daily capacity of 100,000 detainees. Criticism from advocates, immigration advocates, including AILA and the Northwest Immigrant Rights Project, argue this policy removes due process and targets individuals with long-term U.S. ties and no criminal history. Critics warn this is a draconian expansion of mass detention without judicial review. Legal pushback expected. ICE attorneys are preparing to defend the policy in court as legal challenges are anticipated. Bottom line, ICE's new policy drastically curtails bond hearings for detained migrants, marking a sharp turn toward mass detention under Trump-era enforcement priorities, with significant implications for civil liberties and immigrant rights. Social media for foreign student visa applications. U.S. State Department. U.S. will review social media for foreign student visa applications. The U.S. State Department has announced it will resume processing student and visiting scholar visas for foreign applicants, but with a significant new requirement: mandatory public access to social media profiles. This change is part of an enhanced national security screening process aimed at identifying applicants who may pose a threat to the U.S. According to the update, failure to make social media profiles public may lead to visa rejection. Consular officers are now directed to examine online activity for signs of hostility toward the U.S., though specific definitions of what constitutes such hostility were not provided. This policy follows a temporary suspension of student visa interviews in May, which officials said was needed to implement the new vetting procedures. It marks another major shift under the Trump administration, which has adopted a more aggressive stance on immigration, university oversight, and foreign travel. Earlier in May, the administration attempted to revoke Harvard University's authorization to enroll international students, effectively stripping it of its sponsor status. That move was swiftly challenged in court and temporarily blocked by a federal judge. International students are a vital part of the U.S. education system. Over 1 million foreign students are currently enrolled in American institutions, contributing over $40 billion annually to the economy. However, recent policy changes and uncertainty have led to a sharp decline in interest. Data shows that searches for U.S. universities by foreign students have dropped significantly since January. The new screening rules could further discourage foreign applicants, negatively impacting universities that depend on international students for tuition revenue, cultural exchange, and academic vitality. The policy underscores growing concerns over how security priorities may be clashing with the traditional openness of American higher education. H-2B visa cap increased. More workers needed for U.S. seasonal jobs. H-2B visa cap. U.S. seasonal jobs. USCIS. Today, we're diving into the H-2B visa expansion for 2025, a game changer for seasonal jobs in the U.S. Let's explore what this means for businesses and workers. What is the H-2B visa? The H-2B visa program allows U.S. employers to hire foreign workers for temporary, non-agricultural jobs like hospitality, landscaping, and construction when U.S. workers aren't available. For fiscal year 2025, the Department of Homeland Security announced an additional 64,716 visas on top of the regular 66,000 cap, addressing labor shortages in key industries. Why the expansion? With industries like tourism and construction facing worker shortages, this expansion helps businesses meet seasonal demands. It includes 44,716 visas for returning workers and 20,000 for nationals from countries like Guatemala, Haiti, and Colombia, supporting economic stability. Impact and benefits. This move boosts businesses, ensures fair wages, and protects workers from exploitation. It's a win-win for the economy and international workers seeking opportunities. USCIS disclosure of negative information before denial. Today, we're diving into an important update from USCIS about disclosing negative information before denying immigration benefits. If you're navigating the immigration process, this is crucial to understand. Let's break it down. As of June 12, 2025, USCIS updated its policy manual to ensure fairness in immigration adjudications. When USCIS plans to deny a benefit like a visa or green card based on derogatory information, e.g. criminal records or fraud, they must generally share a detailed description with the applicant. This gives you a chance to respond via notice of intent to deny, an OID, or request for evidence. However, sensitive info, like classified data or third-party records, may not be disclosed. This policy, effective immediately, applies to all pending and new requests, promoting transparency. U.S. Immigration Service to change text alert number from July 1st. New USCIS text alert number. USCIS will stop using the number 468 to 311 Gov 311 and begin sending text messages from 872466 USOM. Reason for the change: to make messages more recognizable and improve public trust in official USCIS communications. Action for applicants: save a new number, 872466, to avoid mistaking it for spam. Be alert to scams. USCIS never asks for payment or personal information via SMS. Text alerts usage. USCIS sends updates, e.g. case status, appointment reminders to those who opt in via Form G 1145. Recent policy change. All new permanent residency applications must include a renewed medical examination form. Older forms are no longer valid indefinitely. Application form confusion. A wave of sudden form changes in March caused confusion and legal action, leading USCIS to allow a 2-week transition period for updates. Scam warning. Suspicious messages should be reported on the official USCIS website. Never share passwords or make payments through text. This change emphasizes the importance of staying updated with USCIS communication practices and being vigilant against fraud. That is all for today in this video. What are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take.
USCIS updates peace. Judge extends temporary protected status. I-693 medical exams. ICE moves to end bond hearings for detained migrants. US will review social media as to be visa cap increase. US Immigration Service to change. The US government has enacted major immigration policy shifts for 2025. USCIS has introduced new non-variable immigration fees under HR 1, including charges for asylum applications, Form I-589, Employment Authorization, Form I-765, and TPS filing Form I-821, effective July 22nd. Medical exam forms I-693 now expire with the pending cases. SIJS, Youth Loss Deferred Action and Work Permits, sparking advocacy pushback. ICE will end bond hearings for detained migrants, expanding detention under Trump-era policies. The State Department now requires foreign student visa applicants to make social media public for scrutiny. A federal judge extended TPS for 60,000 individuals from Nepal, Honduras, and Nicaragua. The S2B visa cap has expanded for 2025, supporting seasonal industries. USCIS also now must disclose negative info before denials. USCIS text alert number changed to 872466 for official communication. These sweeping changes impact asylum seekers, students, TPS holders, juvenile immigrants, and employers, highlighting the need for timely update and legal preparedness and evolving immigration enforcement.